morning to all. This rate hearing is now called to order. We now hear a motion dated September 9th, 2022, filed by Tricia Watson and David Simpson for the Commission to order the Barbados Light and Power Company Limited to amend its application based on the Fair Trading Commission depreciation decision dated March 25th, 2022. The Commission has read the motions, and therefore parties are permitted to make submissions on the motions to amplify or clarify any submissions made therein. The time limit will be prescribed as follows. The party making the motion, in this case Watson and Simpson, 15 minutes, followed response by public counsel, 10 minutes, interveners, 10 minutes each, the Barbados Light and Power, 10 minutes, and reply by Watson and Simpson, 10 minutes. Parties will be prompted on the screen when you have 2 minutes left. I now invite Tricia Watson and David Simpson to make their presentation on the motion.
Mr. Chair, thank you. Good morning to the panel. Good morning to everyone present. I am advised by my colleague, Ms. Dean, that she wishes to make an urgent motion to the Commission, and so I, with your leave, will defer to her to make that motion.
Thank you. Public counsel.
Good morning. I'm seeking a review of the order made yesterday not to grant the stay of proceedings. In doing so, I am using the Utilities Regulation Procedural Rules 2003. Under Rule 8.7, it reads as follows. The Commission may permit an oral motion to be made at an oral hearing, and it shall be disposed of in accordance with such procedures as the Commission may order. I'm also looking at Order 53.2 of the very same Utilities Regulation Procedural Rules 2003. Rule 53.2 reads as follows. Any party to a proceeding may by motion request a review of a final decision or order. This is therefore an oral motion to review the position held yesterday in respect to not granting the stay of proceedings. To continue this hearing will result in severe prejudice to the very interveners, BART, public counsel, the general public, and the consumers at large. The Commission has notice of the fact that there is a motion for judicial review in the process of being filed. And if the Commission continues this process, it creates a position where the public counsel is unable to participate in any meaningful way and offer any contribution. The very tenets under which the Fair Trading Commission is created, the fairness, the interest of the consumers, is threatened. Indeed, in the very preamble of the Fair Trading Commission Act, it is supposed to safeguard the interest of the consumers. I also continue to say that if we continue with these proceedings, it represents an unreasonable and unjust, unfair undertaking, which, to my mind, will forever taint the very justice system under which we operate. And it creates a severe hardship and a prejudice to BARP, to the public counsel, the consumers, and the public at large. The Commission is also urged to be cognizant of the Supreme Court's superior jurisdiction and powers, and proceeding without the requested stay would, to my mind, be contemptuous of the Supreme Court of Judicature. It also, to my mind, makes a mockery of these very proceedings. It's also very interesting that if you continue, you've just read out some motions which you wish to discuss and wish us to contribute to. The Public Council does not have these motions. The Public Council, therefore, cannot properly represent BARP, the consumers at large. In fact, it is impossible to represent anybody. You're currently placing us in a position where the Public Council is expected to speed read documents in excess of 3,500 pages, and I go even further, the Public Council is expected, sorry.
Yes.
Can I continue, sir?
We will hear your motion, so I would like you then to do the actual presentation of the motion, because you've started to do that. So the oral motion you're making, we have agreed that we will hear the motion, so we would like you to now outline the grounds of your particular motion.
Well, sir, under section, Rule 53, 53 and 54, I'll repeat exactly what I basically just said, in that to continue these proceedings places the Public Council, BARP, it consists of 30,000 plus strong, and the ministry in a position where we are unable to participate in these matters. And more importantly, there is currently, you have judicial notice of the fact that we are about to go to the courts to have the judicial review process entertained. And we all know that a court of, if you want to say a court of first instance, normally would operate in such a manner that they would consider the fact that we're going to a superior court and indeed stay the proceedings. We also would want to say that to continue with these proceedings creates a situation where it is unreasonable, it is unjust, it is unfair, an unfair undertaking. And this if you continue, the whole notion of justice served, justice must not only be seen, justice must not only be done, it must be seen to be done. And so, using the same, as I went back to use Rule 8.7 as well, I believe I have currently presented this oral motion, which should in fact be heard and addressed, and the other interveners should also be allowed to have at least to say their position in respect to it as well. I also would continue to say again that in the case where if we consider the tribunal to be a first instance court, and if the first instance court has notice of the fact that you're going to a superior court to seek a decision, it would be the normal, usual practice, is nothing strange and or weird, that you would stay the proceedings. And to this end, therefore, I again repeat my motion, which is that the proceedings should in fact be stayed And we should not continue today. Because as I said, as I went on to say just now as well, the Public Council does not even have the very motions that you intend to discuss today. They're not in the Public Council's possession. And they're not in the Public Council's possession, so how would it be possible today to say anything in respect, whether to say whether you should have it, you shouldn't have it? It is indeed not possible. So once again, I urge you to think carefully about the justice system, to also think carefully about the Fair Trading Commission's mandate, and to grant the stay of proceedings. Because otherwise it begins to be almost may have to rename the FTC to the UTC, the Unfair Trading Commission. Because the point that I'm trying to make, again, is...
Yes, Ms. Dean, please rephrase.
Okay, sir, I will rephrase. I said, actually, I did say you would almost have to. I didn't say that that is the name, but anyway.
Yes, but, okay. Don't let us go there.
But sir, you didn't make any, I take note of the derogatory comments by the council as well, sir. But anyway, let's continue. The issue is, once again, that these proceedings should in fact be stayed. That's my submission, sir.
Thank you. We've heard an oral motion presented by Public Counsel to review the decision to deny the stay of its decision made yesterday evening. I now invite the interveners, Barbados Renewable Energy Association, to make a short presentation in respect to the oral motion that has been presented this morning.
Good morning, Chair, and good morning, everyone. We are very sympathetic to the situation that the Public Council is in as an individual. But yesterday we have made our comments on it, and I don't think we have anything further to add other than to say we will abide by your decision.
Thank you. The Energy Division, Ministry of Energy and Business Development, Ms. Cummins.
Yes. Good morning, sir. Good morning, panel. Good morning to the applicant and to fellow interveners. I've just heard the motion put before the commission by my colleague, Ms. Dean. And I rise to say that I support that motion. As was said before, and I'm trying not to delay too much, is that a stay of proceedings is usually the norm and practice in circumstances such as this one, where the extenuating nature of what has happened, that the previous council is out and there was no other council to proceed on behalf of the Office of Public Counsel, or indeed on behalf of the person, its client, who it's representing, which is BARP with its 30,000 plus members behind it, that you usually have a stay of proceedings to permit the new officer to be able to familiarize his or herself with the file, to take proper instructions, as well as to comply with any directions given by the commission, right? That is usually the norm in any other civil proceeding. And I would further add and support that not to grant an adjournment or at least a stay in proceedings will definitely be prejudicial to the interests of BARP and its members, because they would not be able to have representation and to put before the commission their concerns and their suggestions with respect to the rate hearing. And that is very important because that is also protected under the URA. And the commission itself is also mandated to protect the interests of consumers. And yes, I will go further and say they have to balance that as well as the interests of the applicant. Now, I am also of the view that not to grant an adjournment or at least a minimum stay in the execution of the process may very well amount to an unreasonable and irregular or improper exercise of the Commission's discretion, and depending upon the gravity and the depth at which a party to a matter is prejudiced or materially adversely affected, may also amount to an abuse of power. So the Commission has to be extremely careful how it treads. I would respectfully suggest that direction can be taken from how the court proceeds and to come up with what, or to determine what is fair and reasonable in these particular circumstances. And I too would like to urge the Commission to reconsider its position. As I said yesterday, I do not believe the applicant is duly prejudiced because it has been awarded an interim rate, right? And the Commission can, in its discretion, decide what is reasonable or a time for a reasonable stay in these proceedings. I'm obliged.
Thank you, Ms. Cummings. I invite the intervener team of Tricia Watson and David Simpson to speak on the motion.
Thank you, Mr. Chairman. It would be remiss of me if I did not indicate to the chairman that you did not afford the applicant the opportunity. The normal lineup is for the applicant to make their submissions and then to move to interveners, but you would have to advise if you've changed that procedural order.
I will invite the applicant after all the interveners would have made their submissions.
Thank you, Mr. Chair. The Watson-Simpson intervener team now advises the Commission of our intention to apply to the High Court to make submissions in the judicial review application that the Public Counsel has informed she intends to file as a matter of urgency. Our intention is precipitated by our firm belief that the Commission's decision to deny the application for an adjournment is, among other things, a breach of the principles of natural justice and is prejudicial to the intervention of the Barbados Association of Retired Persons, prejudicial to the consumers of Barbados who are represented by Public Counsel, and ignores the policy of the Utilities Regulation Act and the Fair Trading Commission Act, both of which have as primary purposes the protection of consumer interests in Barbados. We also believe that that decision not to grant the adjournment and the decision not to stay the proceedings would be an improper exercise, improper and unreasonable exercise of the Fair Trading Commission's jurisdiction, among other breaches of public law principles. It is customary for the first instance tribunal to give way to the superior forum. This is not a controversial principle. Indeed, in the 2004 rate review application of Cable and Wireless Barbados Limited, which I was in-house counsel for, the then chair, Mr. Justice King, stayed those proceedings pending the outcome of the judicial review hearing on the confidentiality matter before the High Court. We exhort this panel to observe this well-recognized principle in civil procedure. This team, therefore, supports Public Counsel's motion for a review of the Commission's decision not to grant a stay of these proceedings, and we make this application. In fact, let me be more precise. We join issue with Public Counsel's application for a stay of these proceedings pending the hearing of the judicial review application or our own application in that matter. Thank you, Mr. Chairman.
Thank you, Ms. Watson. Intervener Kenneth Lent.
Good morning, all. Thank you, Mr. Chairman. I'm not going to be able to speak from a legal perspective, but I'll tell you that what we have to do when we leave here is to make sure that the public see us in their own perception that we would have done justice, that all sides would have had a fair chance. I'm not sure of anybody in this room who would be in a position to receive 3,500 pages and be able to respond to them without some time. I do believe that through the illness of Public Counsel, no fault, you could not have made a decision when some person is ill, whether you're going to replace them or not. That doesn't appear to me to be good industrial relations practice. So even if we would have liked to see a new Public Counsel in place sooner, we had to be mindful that illness is something that could befell on any one of us. So in this particular circumstances, we know that Public Counsel, the then Public Counsel, Ms. Burke, was ill. It is true that, we still had to continue proceedings, and it was hoped that everything would have been able to go, in order that, we'll have a good balance. But I'm not sure that we would be in the best light of the public to proceed in when Public Counsel, who represents the national interest and the country generally speaking, has only now been appointed this week, just, to be precise, just about 3 days, 4 days after we're going forward. And when you add to that the fact that last weekend, we got the decision of the relief given, the interim relief given to Lighton Paul, the applicant, which says that at least for the next 2 weeks, 4 weeks, whatever the commission feels is reasonable, that there would not be any harm. And I would urge that these particular matters be seen outside of whatever is illegal, even from the, the basic human principles that says, if it was Leighton Paul and the applicant and they had come and said they had that kind of serious thing, we, the interveners, would have been not in the best order to still want to proceed. And I would urge that the Public Counsel, who does not only have the rate hearing, all matters of public interest go before the Public Counsel. I'm sure within the office right now, beyond the rate hearing, there's going to be matters that require attention of the Public Counsel. Obviously, there's something going to have to give because we're down to a question of prioritization. So when we look at all these factors, the fact that Leighton Paul has got granted relief, the fact that the Public Counsel has got to go through lots of information, the fact that beyond what the Public Counsel have to go through, there's still going to be other requests that is going to be in the Public Counsel's office. And when we look at the fact that the most important part is that we want to make sure that whenever these proceedings are finished, that the general public feels that at least, everybody has been given equity. And my team on that basis feels that without a long discussion going on from yesterday, that on further review, and the commission have had reviews before. When I was with Cameron Wallace, we also had a review in the 1992 case. And what was done was that you said, look, we want to be able to reflect, and then all sides were able then to present, and then the commission then makes a decision. I respectfully feel that at this point, we definitely should look seriously at reviewing decision and allowing the public counsel some time. I don't think it's going to serve any one of us good to be heading to court, to taking a lot of time, when we know just 2 weeks, 4 weeks would be much faster in the public interest of all. So with that, Mr. Chairman, I would like to thank you for giving us the opportunity, and I'd like to make it clear. We fully support the decision and request for a review, and respectfully would like in that decision that the public counsel be given some time to proceed. I thank you very much.
Okay. Colonel Brown? Colonel Brown from the Barbados Sustainable Energy Cooperative Society Limited.
Good morning. Good morning, Mr. Chairman. Thank you very much. Good morning to everyone. We, as we said yesterday, fully support the motion by the council, public council. But with your indulgence, Mr. Chairman, I would ask you to give me a couple minutes to say exactly why we feel so strongly about this. And I could warn you that I'm not going to be using any fancy legal language. The cooperative movement which we represent became interested in this whole affair because over the last 30 years or so, this movement has grown significantly to the point where now we are intimately interested in investing in energy. And we wanted to be part of the process to educate our members and to become aware of how the power industry works in Barbados. Our expectations, sir, were, when we got involved, that the customers of Barbados are financially stressed. We were worried that the Barbados Lighting Power itself had become financially stressed. It is no question that we need, it goes without saying, sir, that we need a reliable electricity service in Barbados. But the final expectation that we came into this exercise with is that the Fair Trading Commission is an unbiased, fair referee in the whole affair. Given those expectations, we were keen to play a role in addressing the complex challenge that they present. I have to tell you, sir, and I say this in all honesty from our honest, reflective perspective. What we have found, true, it does appear that the Barbados Lighting Power is under some level of financial stress. There is no question that the public of Barbados is under financial stress. But what we have found, sir, that is most disappointing in the last year or so that we've been involved in this process is that it comes across as though the Fair Trading Commission is more concerned about the concerns of the Barbados Lighting Power than any of the other players. One of the things that strike us most in this whole exercise is that the Barbados Lighting Power Company Limited is not a private company. It is a regulated public utility who exists for the public good of Barbados. And the key stakeholder in that whole exercise are the customers of the Barbados Lighting Power Company Limited. These are the people that need to be represented most in the affair. And so when you look at the process, what we have seen and what we have found is that this seems to be the least important among the apostles. Just to give you a couple examples of why we have come to this conclusion, sir. When this exercise started, Lighting Power applied for a rate increase. No problem, we expect that. As a matter of fact, our position is that this should happen every year. This should be a regular thing to make sure that the equation continues to be balanced. So no problem with that. Immediately after that, Lighting Power applies for an interim rate increase. Sir, we do not know what that is. That's not in the law. But somehow, it was found that that was a reasonable thing for Lighting Power to do, so there are now 2 applications before the FTC. Okay. Then Lighting Power applies for a confidentiality hearing. This, in a regulated public utility, where the key stakeholder is the public of Barbados, my constituents, sir, we have difficulties with the concept of confidentiality. In the credit union, in the cooperative movement, it does not exist. I do not have that luxury, sir. So I therefore cannot sign a document that says that I'm not going to say to my members things that I know about something that I'm representing them on. So it puts me in a difficult, we wrote to the commission and explained that. We have not even had the courtesy of a response. Sir, Lighting Power submitted a complaint after the FTC set dates in November, and they said that that was not convenient for them. They were facilitated, sir, in a meeting to discuss what would be reasonable for them. We had ongoing discussions, and we came up with the dates that Light and Power was happy with. I have no problem with that. But during that same meeting, the public counsel, the dilemma that they faced was also discussed. So isn't that we didn't know that they had a problem with illness, with serious illness? It was completely ignored, sir. My question is, and our concern is, here is the council representing the general public of Barbados by statute. How is their concern less important than Light and Power's concern? Light and Power have difficulties with their experts. Everybody have difficulties. The same way that Light and Power was treated with the courtesy of a hearing, understanding what their concerns were, and adjustments to accommodate them, which we supported, by the way, sir. We feel that the same is due. I mean, and this should not have to go to any court to have to say this. It's actually an insult to Barbadians to say that we have to go to a court to say that both sides should be treated fairly, sir. We unhesitantly and reservedly support the motion. And we think, sir, that if this even has to go to a higher court to say that fairness must prevail, it will be a slap on the FTC. And we urge you, sir, that right now to make a ruling that will give the people a chance to actually do their job, and they close on that.
Thank you, Intervener Brown. I would just want to make a simple statement in relation to the confidentiality hearing. The purpose of a confidentiality hearing is that in an application made for a review of rates, certain information will be provided by the applicant that would assist us in evaluating the decision. There were certain pages in the application which related to national security issues. And all the applicant was seeking in that application is that things that pertain to the national grid of Barbados be kept in confidence. That was the purpose of the confidentiality hearing. And all of us as Barbadians would want to ensure that the safety of our grid is kept confidential. So that was the purpose of the confidentiality hearing. So it was not to hide any information, but particularly to ensure that all Barbadians are kept safe. And all interveners were presented with the information at the hearing, and we all would have agreed that some of those pages would have been redacted in the application. That was the purpose of the confidentiality hearing. I now invite the applicant, the Barbados Light and Power Company, to respond to the motion for a review of the decision to stay that was given yesterday.
Thank you, Chair. I understand that this is a motion to vary or review a decision of the Commission that was issued yesterday. Of relevance would be Section 54 of the URPR, which sets out the requirements where someone seeks to vary a decision. In setting forth that motion, a person must speak to error of law or jurisdiction, error in fact, most importantly, change in circumstances, new facts that have arisen. The only law quoted by my friend relates to what she perceives to be her right to bring this application and bring it orally, and I will speak to that at a later time. But all the circumstances, facts that have been delineated by every intervener in this matter were raised with this Commission yesterday. There are no new facts that have been placed before this Commission to suggest that there's a factual basis to reconsider. It is of import in terms of this application that we recognize that the Public Council is not a party to these proceedings. Section 9 of the Utilities Regulations Act sets out her role in these proceedings. She is an assistant to the consumer. And that is important because at the end of this day, the review that has been requested here is no better than the original motion that was brought by the Public Council. In that original motion, she makes it clear that she's acting in and of her own right. She does not act on behalf of the Ministry of Energy, who withdrew their request for adjournment. She was acting in and of her own right. Public Council is not a party to these proceedings, and by virtue then of, and let me clear, she makes this clear at paragraph 9 of her motion that she's acting in and of her own right. The only person who can request a review, 53-2, is a party to the proceedings. And before she can request a review, that party, such a person would need leave of this commission. So we have a problem relative to locus standi in the context of her ability to bring the application she has made. We have a problem relative to the fact that no law has been stated in support of why she's requested this review, and no new facts or evidence has been laid or suggestion of change of circumstances to support the review. A lot of statements have been made as to what is normal practice and a reference to superior courts. The CPR Act Rule 60.3 makes it clear that no appeal operates as a stay of proceedings. That is norm. You need to get that stay either from the appeal court or the tribunal or court where you are. This tribunal has already indicated its position relative to the issue of stay. There's no suggestion that this tribunal and commission is not appropriately within its rights to proceed in this matter, pending any application that any party may wish to bring to the court. When a party places a court order before this commission indicating that it must act in an appropriate way, I'm well assured that the commission will do what is necessary in line with any court order that has been granted. But until that court order has been issued, this commission should proceed and move forward in the hearing of this matter. And we have to correct the false narratives that keep being repeated, and to the extent that they're repeated, the idea becomes that they somehow have some level of truth. My friend would just have indicated that there was a request for an adjournment by the Barbados Light and Power, and the commission facilitated it after they had set forward certain dates. The motion initiated by the commission was predicated on a request by an intervener for an adjournment in these proceedings. It was not of its own motion. An intervener asked for an adjournment, and the commission acceded to it by saying, let's discuss this matter. To suggest at the end of the day that the commission, which has worked in a balanced manner to help interveners, put forward an application in that form to assist an intervener who needed an adjournment, then to be assailed as to the nature of the activity and why the activity is quite questionable and unfortunate. During those proceedings, the dates put forward by Light and Power were not accepted, and Light and Power compromised new dates. That is the truth. That is what occurred. So let's stick with what is real relative to the stories we put out and which we have the public have to consume. We definitely oppose this motion. There's no legal basis for the motion. There's no factual basis for the motion. And there's no new evidence or facts for this commission to change its decision. Thank you. There is, sorry, Chair, there's one point which comes in the context of how this commission should view its activities. There is a Substance Authority muck law and the Minister of Home Affairs civil appeal. The fact that courts are driven to formulate some tests which can exclude cases where judicial review is considered inadvisable, even though the rules of natural justice have not been observed, as a matter of practical good sense, it's clear that administration would considerably impeded if every decision of all administrators were acceptable to review by the courts on an allegation that rules of natural justice had been breached. The effect of total supervision may well be total frustration of indispensable administrative process. And that is what we are involved in at the moment, an indispensable administrative process which interveners themselves suggest should be happening more often. But on a mere allegation or a suggestion without any basis, we are asked to shut down proceedings, increase costs, make consumers wait, so that a person could take tenuous claims to the Superior Court. The issue of the representation, and I am not sure whether BARP is joining or part of the application in the context of what has been put forward by the Public Council. BARP is an incorporated body. BARP does not have a right to be represented by the Public Council. A group of consumers can seek, on the direction of the Commission, to have the Public Council assist them in a matter. BARP is not that. We are welcoming BARP's involvement in these proceedings, but at the end of the day, if the rules and procedures have to be followed, they have to be followed. So any application on the part of the Public Council relative to adjournment of these proceedings really and truthfully should not be linked to any interests of the Barbados Association of Retired Persons. And to the extent, as I said, that she has made it clear within her original motion that this is a personal application, she, being not a party to these proceedings, lacks certain judicial standing to bring this request for a review. Thank you.
I invite Public Counsel to respond.
Thank you. My learned friend spoke about false narratives, and indeed, he did make some points which were false narratives. So what I want to point out is that Rule 54.1a says these are the grounds that it may include. May is a very important word there. It may include those. All those grounds would not have to be there. Secondly, when you look at 54.1a6, it says an important matter of principle that has been raised by the order or decision. Now, it is an important matter that has been raised, which is the prejudice which obtains to the consumers of Barbados, the prejudice which obtains to BARP. I also go on to point out, and I'm using back my learned friend's words, false narratives. In fact, I even consider it to be horrendous to suggest that BARP, the retired persons in Barbados, that these 30,000 plus persons are not even, I think you suggested, I don't want to misquote you, but I think you suggested that they're not even really parties to this matter. I'm not sure if I'm quoting you correctly. They're not proper parties. I think that's the correct thing that you said. It is horrendous.
Just for the record, that was never stated.
Perhaps, what I would say, perhaps I'm paraphrasing. I would maybe concede I may be paraphrasing, but I know what was said, what I heard, but what is being implied. I also wish to point out as well that the BARP have been, Barbados Association of Retired Persons, they have been recognized as interveners and represent as, not only recognized as interveners, but they have been recognized as interveners who are represented by Public Counsel. I also wish to point out that in one of the procedural notices, it specifically said that if you're represented by the Public Counsel, you cannot then speak. You're not expected to speak in the proceedings. So it's has to be a false, I keep using back my learned friend's words, it has to be a false narrative to suggest then that the public council really and truly has no stand-by, because clearly the public council is representing BARP, and BARP is a consumer body. And I think we also need to look at the rationale behind the creation of the post of public counsel. Public counsel, yes, you look in there, you see section 9 speaking to advice, but you have to look, when you look at an act, you look at the rationale behind which an act was created. Why was there a need for the post of public counsel? There was a need for the post of public counsel because you have to represent the consumers. Every intervener may not be able, every consumer may not be able to hire, like the BLPC, 20 attorneys or a whole firm of attorneys. The consumer may not be able to do so. And that is the rationale behind which the public counsel, the post of public counsel, was created. And behind that backdrop, that is the backdrop behind which the public counsel is therefore representing the Barbados Association of Retired Persons. I also go even further. It is ridiculous to make the comment that the public council has no locus standi, because, first of all, we're representing the Barbados Association of Retired Persons. And also, the very commission, I repeat that again, the very commission has acknowledged that the public council is indeed separate and has locus standi. I point you to the very order of proceedings. After presentation of each witness called by the applicant, the parties are at liberty to cross-examine each witness in the following order. A, the public counsel. B, the interveners in order of intervention. And then it continues down the road. And at some point, at the bottom of that, it then mentions the Barbados Association of Retired Persons. Separate in that list of proceedings from the public counsel. And so I'm not sure I'm following. At some points, the public counsel has locus standi, and at some points, the public counsel does not have locus standi. Even if you were to say, which I don't agree with, I categorically do not agree with it, that the public counsel does not have locus standi, but even if we were to say that, are we still forgetting that the public counsel represents the Barbados Association of Retired Persons? Are we forgetting that? In fact, my learned friend, in his continued false narrative, his very words, not mine, he said pretty much that, BART basically represents themselves, and I think he said they're not proper parties, or something like that. And, to me...
I repeat, Chair, to correct the record, I never said that BART was not a proper party.
I think you said that they were an incorporated party and a body which cannot be represented by the public council, which is in fact a false narrative. It is in fact a false narrative, because clearly this very commission has recognized that the public council is representing BARP. So how is it that you are reprobating and approbating at the same time? How is it that at one point, it seems like you're a little confused, because at one point you're acknowledging that public counsel is separate. And then another point, you've actually gone so far to say that. You've gone this far. You've said that when you're represented by public counsel and BARP is represented by public counsel, they themselves cannot speak, that the public counsel would have to speak for them. So if the public counsel has to speak for them, how will the public counsel, who is not a proper party, speak for them? It is almost not making sense. I want also to add that at the end of the day, justice must not only be done, it must be seen to be done. And to me, if it is that the public counsel is representing the Barbados Association of Retired Persons, and I know you may not agree with this, and they also have a local standard based on the Act, based on the rationale behind which the Act was created. It's created so you don't have a situation where a conglomerate such as BLPC would be able to prevent a small person who has no money from actually participating in a rate hearing such as this. So I once again make the point that my learned friend accused me of having a false narrative. But in fact, I'm sure now that you've listened to me, you now understand that the false narrative really and truly was that of my learned friends and not the public counsel. To this end, therefore, I again renew my submission that for my motion that the stay of proceedings should in fact be accepted, as would be the usual regular practice of of a first instance court in deferring to a more senior court, a more superior court. Sir, I therefore rest my case.
Thank you, Public Counsel. We will now adjourn to consider the motion.